Gweminar pawb. Good afternoon, everyone. Thank you very much for joining us today for the Cardiff University Will Writing webinar, which we're holding in conjunction with HCR Law. My name is Esther Liu. I am the Legacy and In Memory Officer at Cardiff University, and I have the huge privilege of working with donors to the university and with students and researchers who are accomplishing astounding things thanks to gifts left in wills by people like you. When you sit down to consider your legacy with a solicitor, after providing for your loved ones, would you consider leaving a gift to researchers or students at Cardiff University? If you want to know more about the impact that you can have, you can absolutely contact me. My details will be on the follow-up email that you'll receive next week. You'll also receive a link to this session as we're recording it, and that'll be available next week too. The Q&A function will be available as soon as the presentation begins, and we'll try to answer as many questions as we can at the end, including those submitted beforehand. So it's now my pleasure to introduce Cardiff alumna Laura Ikin, who's a Senior Associate Solicitor at HCR Law, specialising in providing advice in relation to wills, lasting powers of attorney, trusts, tax and estate planning. Thank you so much, Laura, for your time and your kindness giving your expertise to us today.
Thank you very much. Thank you for having me. I'll just share my screen now and we can begin. So here we go. As Esther said, thank you very much for joining us today. Today I'll be talking about the importance of making a will, wider estate planning, hopefully answer some of your questions as well that have come in, as I know we've had quite a few already. So to start with, just to introduce myself, my name's Laura Ikin. I'm a Senior Associate in the Private Client Department at HCR Law in Cardiff. I specialise in all things private client, so wills, inheritance tax planning, estate planning, powers of attorney, trust advice and probate as well. And to give a bit of background about the firm, we are one of the UK's leading law firms. We have our Cardiff office, but are also part of a bigger network with about 10 or 11 offices, mainly spread across the M4 and M5 corridors. And we are full service law firms. So we have the benefit of our Cardiff office is very friendly and very client focused for people to come in and see us, but with the benefit then of having a bigger network of colleagues across the other offices, pretty much covering all other areas of law that you possibly could need to have advice on. So enough about that. Moving on to what we're talking about today. Preparing a will. Preparing a will is the only way really to ensure that those that you want to benefit on your death receive what you want them to have. Without a will, the intestacy rules apply, and I'll come on to those in a moment, but this can likely leave you and your family with a legal headache, probably a practical headache in dealing with things, and also potentially an unnecessary inheritance tax bill. I'll also say that with a will, it isn't just a case of getting it done. That's obviously a very important starting point. But it's important to keep it under review and review it regularly as and when things happen during your life and, as situations change. So we always say every kind of 5 years or so, or as and when things happen, is a good time scale to think of and keep in mind. So looking at wills, these are some very common reasons that I hear very often from clients as to why they don't have a will in place. A lot of people think, oh, I'm married, my spouse will automatically get everything. This isn't necessarily the case. Depending on how the estate is set up and the family set up, not everything will automatically pass to your spouse. Looking at the second point, lots of people think, oh, we've been together years, we're common law husband and wife. That if you're not married or not in a civil partnership, it doesn't give you any legal right really to benefit from your partner's estate. There are some exceptions, but obviously it can leave then a surviving partner in a really tricky situation. And the third point I hear a lot, I live with my partner, but we're not married, so we don't need a will. Again, probably even more so, that is a situation where you really should have a will in place. I mentioned the intestacy rules. So looking at wills, the intestacy rules are the list of who benefits that the government set out if you don't have a will in place. If there is a surviving spouse and no children, then everything would pass to the surviving spouse. However, if there are children, personal possessions would pass to the surviving spouse. The statutory legacy, which is currently £322,000, that first amount would pass to the surviving spouse. If there's anything above that in the estate, it's then divided between the spouse and any children. And the children would take their shares on reaching the age of 18. And depending on the value of the estate, could create an unnecessary tax bill. So it does create some problems down the line. If there isn't a surviving spouse, then this is the order in which people would inherit under the intestacy rules. So you can see if there are children, it would go to children. If there are no children, it would pass up to parents. If there are no parents, it goes to siblings, etc., etc. And it filters its way down through the family line. And if you get to the end point where there's no uncles, aunts, nieces, nephews, it actually ends up back with the government. It's important to highlight, so you'll probably have noticed that under the intestacy rules, there's no legal entitlement for a surviving partner or surviving cohabitee to receive anything. So as you can imagine, this can create a difficult situation. For example, if it can result in a deceased share of a property or money passing under the intestacy rules to their parents or siblings or children, and then the surviving partner not receiving anything. Unfortunately, more often than not as well, we tend to see that these are situations where not all the parties are getting on very well together. So it automatically creates a situation of conflict, which when someone is grieving and going through a lot of change isn't ideal. The only way then that the survivor may be able to benefit from the estate of the person who's died is to make a claim under the Inheritance Act of Provision for Family Independence, which involves, instructing a solicitor, paying fees, potentially going to court. And all of this would have been quite easily avoided by preparing a will. Having said that, there are some assets that pass outside a will. Those are assets that are owned jointly. So, for example, a house that's owned as joint tenants or a joint bank account will automatically pass to the other co-owner on the death of one of those co-owners. So if you have a joint bank account with your partner, you don't need to be married, your spouse, it could be, some people have joint accounts with their children. If you then died, everything that's in that account then would automatically pass to the other owner. And the same way, if you own a property as joint tenants, then that whole property will automatically pass to the other co-owner, and won't necessarily form part of the estate that's passing under your will. Similarly, pensions will pass outside of your will, provided you have an expression of wishes that's been prepared and up to date. Same with death and service benefit. Usually you will have nominated a beneficiary, and that payment will pay directly to them. Same for life insurance policies. So they are usually written into trust, and you will name then the beneficiaries to receive the payment on your death. So they don't form part of your will, and they don't pass in accordance with your will. I mentioned inheritance tax briefly, so just to give a bit more information about people's inheritance tax positions. I'm basing this, I will say, as things are at the moment. We have a budget coming up very soon, and I think I did this last year thinking we wouldn't really be affected by it, but some big changes were brought in, so you never know what will happen. Currently, though, inheritance tax is paid on assets at a rate of 40%, and it's charged on everything that's above the nil rate band. And currently, the nil rate band is £325,000 per person. It has been that amount for many years, so we don't really see that increasing. And what we are seeing then, though, is more and more people being drawn into the inheritance tax bandings, because obviously house prices are increasing and dragging more and more people into paying tax. The nil rate band could be higher for some. So certain people, if you satisfy certain criteria, can qualify for an additional £175,000 allowance, and this is known as the residence nil rate band. And this is an additional relief that the government brought in a few years ago now, which, if you satisfy the criteria of having a property or having owned a property that you are passing to your direct descendants, which is children, grandchildren, stepchildren, primarily, and the value of your estate is under £2 million on your death, then you can potentially claim up to this £175,000 extra. So it brings the maximum tax-free allowance for a person to £500,000 when you add together your £325,000 and this additional £175,000. There are exemptions as well for inheritance tax, one of those being a spouse exemption. So anything that you leave to your spouse, whether you have £10,000 or £10 million, if you leave that all to your spouse on first death, then there shouldn't be any tax to pay at that point, because gifts to spouses are exempt from inheritance tax. What you see then is on that the second death, so the second spouse to die, they would then claim their nil rate bands and the spouse's nil rate bands that's rolled over to them. So the inheritance tax kicks in then on second death. Same for charities. There is an exemption for gifts to charitable organisations. So any gifts that you leave to a qualifying charitable organisation in your will are completely free of inheritance tax. There are reliefs available for business and agricultural property as well. And this is a big change that was brought in by the budget last year and is coming into effect next year. As things stand at the moment, if you have business or agricultural property that qualifies for the relief, is completely free of tax. As I said, that's changing next year. The best thing to do, I would say, if you have assets that qualify for that, is to take advice and make sure that, you know, your wills are structured in the correct way to make sure you get as much of a tax relief as possible. And then there are lifetime gifts as well that you can make to bring down the value of your estate. So there are some exemptions. So during your lifetime, any gifts that you make to charity are outside of your estate, taken out of the value of your estate immediately. There are certain allowances, so you can give up to £3,000 a year yourself. So you have a personal allowance of £3,000 a year that immediately comes out of the value of your estate when you make that gift. Smaller amounts of up to £250, you know, gifts to family members, etc., they are immediately out of your estate. And also gifts on customary occasions, so weddings and the birth of a child, the government actually set an amount that they think is, you know, acceptable for you to give on those occasions that again will come out of the value of your estate straight away. I've noted there the 7-year rule, and I'm sure lots of people have heard of that. So what that relates to is basically any other gift that you make, and they are referred to as potentially exempt transfers, or PETs, as we call them. And that is basically any other a gift of an amount that you give to someone. You have to survive for 7 years from the date of that gift in order for that value to drop out of your estate. So if you had £200,000 in the bank and you wanted to give that to your child or grandchild or family member, you're more than welcome to do that. If you make that gift tomorrow and you died within 7 years, your estate is still treated as if it has that £200,000 in it for the next 7 years. Once you get past the 7 years, then the value drops out of your estate and obviously reduces the value of your estate for the inheritance tax reporting. I mentioned charitable giving, and as Esther said at the start, your will is a really good way to think about who else you want to benefit after your days outside of your family and friends. Lots of clients don't initially think about it as something that we talk about when I meet clients and talking about wills, is whether they want to consider making gifts in their will, and can then give some advice surrounding that. There's lots of good reasons, obviously, to leave an amount to a charitable organisation in your will, and that could be, one of the large charities, smaller local charities, churches, Cardiff University in particular. One of the main reasons and benefits of doing so is, aside from obviously benefiting an organisation you feel strongly about, is there's inheritance tax advantages as well. So bequests, as I said, to charity are completely exempt from inheritance tax. And if you leave enough of an amount, which works out as it's 10% of the chargeable estate of your of the residue of your estate, which isn't as straightforward as you think it is, and it's not as large an amount as you may think. It's a fairly complicated calculation, but if you leave that amount to charity, it actually reduces then the tax rate from 40% to 36%, so you're paying a lower rate of inheritance tax. Another point that I've just added in, which lots of people don't know about but can also be worth considering, is you can prepare a deed of variation within 2 years of someone's death. And what that does is it essentially changes their will. So the main examples of this that I've dealt with in recently are either someone who's died has left an amount to charity in their will, but it's actually quite close to the amount that they would need to leave to get the lower rate of inheritance tax. So provided all the beneficiaries agree, within 2 years of that person's death, they can essentially change that person's will to give a bit more to charity, and then the charity benefits more, and they've then been able to claim a 36% rate of inheritance tax as opposed to 40%. And another example of this is an estate that I've helped with, which is still ongoing, where a person has passed away. There were no charitable legacies in the will, but the beneficiaries of the will actually then wanted to benefit charities from the money that they've received. And we worked out a calculation, roughly how much they would want to leave. We worked out that that would actually be enough to be able to claim the 36% rate. So we've done a deed of variation then to essentially, it's treated as if that gift is coming from the will of the person and is allowing the estate then to give more money to charity and save a bit on inheritance tax payments. Just to put that into an example with actual figures, this is, if we look at the estate, Mr. and Mrs. Bale, for example, their estate is worth £2 million, and that's, a house and savings. They have a nil rate band between them of each of £325,000 each, and a residence nil rate band of £175,000 each. So after both of their days, that's an estate of £1 million, which is tax-free, and then there's £1 million which can be taxed. So at a rate of 40%, that tax bill would be £400,000. Looking at Mr. and Mrs. Ramsey, exactly the same estate, coincidentally, but they've decided to give a gift to charity, and they've left £140,000 to charity. That is immediately tax-free, so their taxable estate is reduced to £860,000, and then with tax at 40%, that's £344,000. So more going to charity, less going to the government. But what's very interesting, looking at this, Mr. and Mrs. Allen, again, really handily have got the same value estate. So their taxable estate is £1 million after allowances, but they've given just £10,000 more to charity, which brings their taxable estate down to £850,000, because that £150,000 to charity is completely free of tax. But they have triggered that lower rate of inheritance tax. So rather than paying 40% tax, they're paying 36% tax, which is £306,000. And if you look at this on a table, it shows there the difference between Mr. and Mrs. Bale paying £400,000 and Mr. and Mrs. Allen are paying almost £100,000 less in tax. The family, generally speaking, aren't receiving that much less. With the charitable gifts, the charities are receiving obviously quite a considerable sum. But the difference is there, in particular, the last example, Mr. and Mrs. Allen, the family are only receiving £50,000 less, give or take. The charity are receiving £150,000 and the government's receiving £100,000. So it's well worth, if it is on the cards and you do want to start thinking about making a charitable donation, it's well worth kind of working through the figures just to see if it's, you know, if it makes sense to perhaps up the charitable donation slightly, which obviously gives quite considerable tax savings. Moving on to looking at the practicalities of making a will, because I know we've had lots of questions of, you know, where do I start? What do I need to think about? I see lots of clients, you know, weekly who maybe have been putting it off for ages and have come in and said, oh gosh, we know we've needed to do it, but our circumstances are complicated, or we're struggling to decide what we want to do, or our circumstances are going to change. A really common stumbling block is we can't decide who we'd appoint as guardians. And as lots of people say, it's something I'll get around to one day down the line. And again, these are scenarios that I come across here, and I thought I'd share some common dilemmas because I'm sure lots of people can identify with them when, you know, we are talking about wills and reasons that perhaps you haven't maybe done a will or updated it, because these are dilemmas that you're not quite sure what to do with. Most commonly it's, you know, I'm worried that perhaps my son or my daughter, if I leave my estate to them and then they divorce, you know, my estate is then diluted and is taken as part of a divorce settlement. I'm concerned my spouse will remarry if I leave everything to the spouse, and then my children won't receive everything. My, you know, a daughter or son or family member working in a family business, and it's how do you balance that equally between everyone? Is providing, you know, for a disabled beneficiary perhaps, and not knowing how to do that, or being concerned about your children receiving too much money at, you know, too early an age. All of these scenarios I see daily and can very easily be dealt with through your will. So I thought just to set out the will planning process. So, you know, it's a case of, first of all, well, I think you've kind of got to step one, which is probably signing up for this webinar. I would say stage two is then making an appointment. And I know it's so difficult to know where to go, who to speak to. And and, you know, how to even get started. But I think the next stage is make an appointment to speak to someone. Me, another solicitor, you know, someone that has been recommended to you. And that can, say it's me, I would usually we either meet in person or through a Teams call or a phone call. And the first step is doing a bit of a fact find to find out what's in the estate, how much is it worth, understanding your family circumstances, what your objectives are, what your concerns are. And I've got my skeleton in the closet, because I always say it's so important that I know everything to be able to advise you fully, because lots of clients, you know, have things that have happened in the past. But if you don't disclose them and you then pass away and perhaps you haven't had advice on it or made provision for it in your will, that can cause problems down the line. For example, you know, say someone is paying maintenance or giving money to a family member, but perhaps their spouse or partner doesn't know they are. It does happen. The issue then, though, is if that person dies and you've got someone then who is receiving this money and is relying on it and then hasn't been provided for in the will, it actually gives them quite good and strong grounds to bring a claim against the estate. Whereas, obviously, if that was factored into the will, it kind of eliminates that risk. So once we've done that and we've had a chat basically to find out what the situations are, I would usually then give a range of options and structures for the will that would best suit your needs. And there's different types of will, different things for you to consider. There's no right or wrong. It's all about making an informed decision. Once we've done that, I would usually then go and prepare the draft of the will for you to check over, make sure you're happy with it. Once it's all approved, it's then signing it and meeting again to sign it to make sure it's valid. And wills have to be signed in a certain way to make sure they are valid, in that they are signed, dated, witnessed by 2 witnesses. And it's amazing how many people go wrong with that, and then you know, turns out the will isn't valid because it hasn't been executed properly. So just to run through, I mentioned different types of will and things for you to think about. So the starting point I always started is, you know, a straightforward will. And that would be basically saying I leave everything to my spouse, my children, my partner, to charities, to friends, depending on your circumstances. And the main things to think about there would be who your executors are. So the executors are the people who will deal with everything. You can include funeral wishes. I know we've had a question about, you know, how you want your body to be dealt with. You can include there if you want your body to be donated to, say, Cardiff University for medical research purposes. You can include that in the will. Personal possessions can also either go in the will or in a side letter, and that keeps it nice and straightforward and, you know, easy to deal with. What I would say, and I always say this to clients, is depending again on your circumstances, by leaving everything to the survivor of you, for example, if you're married, then you are leaving the entire value of the estate in the hands of that person, and it's vulnerable to their circumstances. So if they needed care, if they were to meet someone else or remarry, then there's no protection over that, your share of the estate. It's all in their hands. There can be inheritance tax consequences if you're unmarried and you keep things very straightforward and leave everything to the survivor of you. Again, if you're leaving everything to children, you can see them inheriting potentially quite large sums of money at an inappropriate age or time. And it's, you know, it's important to take advice, because this type of structure of will is potentially creating inheritance tax bills generationally down the line. So the way to add a bit more control over your estate in the will is to include trusts in the will. And these are very very common to do these days. So a trustee is essentially a way of making a gift with strings attached. It allows you flexibility and control as to how you provide for beneficiaries. So it doesn't form part of their estate, it doesn't fall under their control, but they have the benefit of it for a certain period of time. There's different types of trust that we'd include in wills. I'll highlight the main two that I talk to clients about, being life interest trust and a discretionary trust. A life interest trust is basically a way where you can ring fence your share of the property or your share of cash or savings or assets on first death. So if you passed away, not everything passes automatically to the survivor of you, but it's held on the terms of the trust. And the survivor of you has the right to carry on living in the property, have the benefit from it, benefit from any income generated from savings for the rest of their life. But if they needed to go into care or if they were to remarry, it's only what's in their name then that is vulnerable to their circumstances, because the share that you've protected on your death to ultimately pass to children or family members is ring-fenced in that trust. So it's a really good way, quite unobtrusive way of making sure that perhaps your share is passing to children, but providing for the survivor of you for the rest of their life as well. And this is the type of trust that I always recommend to people who are in second marriages, because it balances that obligation of making sure that your spouse is, can stay in the property, is financially comfortable, but making sure that perhaps the children from the first marriage or relationship are also going to receive something ultimately at the end of the day. The other type of trust that's most common to put in wills is a discretionary trust. And this is a good way to pass wealth on in a very flexible and measured way, because it's held in trust, but none, you name a pool of beneficiaries, but none of those beneficiaries have an automatic entitlement to what is held in the trust. It's also a very good way to give effect to some more complicated wishes, which wouldn't really work in a standard will setup. We'd also use a discretionary trust to provide for a cohabitee or an unmarried partner, to give effect to essentially like that life interest trust setup, but in a more tax efficient way. We would also use a form of discretionary trust to pass assets on that qualify for business relief or agricultural property relief. And we'd also use a form of a discretionary trust to provide for a beneficiary who is perhaps vulnerable or has a disability, because it's important to note that if you are benefiting someone who has a disability, learning needs, is vulnerable, and they are receiving care or receiving benefits, any inheritance that they receive from you is going to affect their benefits and their care package. So you can use a trust to make sure that they still have the benefit from your estate, but their care package and their benefits are not being affected. When you prepare a discretionary trust, it's really important that you prepare a letter of wishes that sits alongside it. And what that does is it gives more detail as to how you envisage that trust fund being used. It's important to note it's not legally binding, and that's where it's really key that you pick the trustees that you trust to make the right decisions on behalf of you and your estate. And finally, moving on from wills, just to mention, as I always do when I meet all my clients and we talk about wills and estate planning, I always mention lasting powers of attorney as well. Lasting powers of attorney are completely separate documents to your will. A will takes effect on your death. A power of attorney is a document that you prepare that is used during your lifetime, but it's if you lose capacity or lack the capacity to make your own decisions. There's two different types. There's one that covers property and financial decisions. The other covers health and care decisions. And it allows you to name attorneys to step into your shoes and make decisions on those topics if you don't have the ability to make those decisions yourself. They are really important. Without a power of attorney, there's a risk that your assets will be frozen, even a joint account. And I'm sure we've all had experiences where you phone up, you know, Sky or utility company or the bank, and they say you're the named account holder. If you're not, they ask to speak to the named account holder. If the named account holder has lost capacity, it's very black and white. They won't talk to you and you're stuck. The only option then is to make an application to the Court of Protection to have a deputy appointed, and a deputy is a court-appointed attorney, but that's a very expensive process. It's an ongoing process because there are annual charges, and it's not ideal. So the best thing to do is to prepare power of attorney, have that in place. I always say you don't need a solicitor to do it. You can go online and look at the forms yourself as a starting point, and then work out if you think you're up to doing them. They are a bit of a faff, but that's where then I would be more than happy to help if you decide you want to do them. So there we go. I think in conclusion, to a whistle-stop tour of wills and estate planning, essentially it's don't put it off. Make an appointment, make that call, make a will or review the existing one. It's always important to seek specialist advice, especially, tailored to your particular situation. And while you're at it, have a think about powers of attorney as well. There we go. So I think now if there are questions, I'm happy to answer them.
Thank you so much, Laura. If any of you missed the start of that presentation, I highly recommend that you go back and rewatch this when you get the follow-up email next week. We've had some really helpful things to think about, and it might be helpful to sit down and watch this with your spouse, with your partner, and think through these things together. We have received some questions. We're going to try and speed through them, but if we run out of time, HCR Law have agreed that they can offer a 30-minute free phone consultation to any of our registered attendees. So yeah, look for information on that in our email next week as well. Or of course, you can contact any solicitor who can advise you on these things. So Laura, just kind of quick fire, you mentioned about charitable giving. Can you only give to one charity, or can it be multiple? Can it be split?
It can be multiple, it can be split, it can be as many charities as you want. I actually have quite a few clients who've got quite sizable estates who use their nil rate band to make gifts to perhaps family or friends, and then the remainder then is left to various charities, and then that is a really tax efficient way because they're not paying any inheritance tax on an estate that's a few million really. So there's no limit at all on how much you can leave and how many charities or organisations you can benefit.
Amazing. On that nil rate band, you mentioned how it gets transferred to a surviving spouse. Is there a way of stopping that, or is that just automatic?
There are ways of stopping it. Generally speaking, it's automatic, and it gets claimed that rollover on the death of the second person, but it's very dependent on how the estate of the first person to die is structured, which again is where it's important to take advice depending on what you want to happen. But depending on how that first will is structured, if someone dies, potentially you don't have the availability to roll over that allowance. As I said, there's no right or wrong, but it's very dependent on your situation and what a person wants to happen. And then we can tailor it to their wishes.
Yeah, I know a lot of the questions that were coming in when I was kind of chatting through them with you before, your answer was very often, this person this is so specific, they just need to talk to someone. And so, yeah, if your questions don't get answered, really do talk to someone. What about storage of wills? How does that work? What are those options? And do we have it in our house under our bed, or kind of, yeah?
Preferably not, but there's no, I suppose, official place where they have to be stored. When I do wills for clients, we tend to ask the client what they want. If they want to keep it in their house, in their safe, or, you know, in their box with all the important documents, they're very welcome to. We tend to store ours in a secure, you know, waterproof, fireproof unit, and that's where all our wills get stored. We don't charge storage fees for them, and then if someone wants to obtain them, all they need to do is contact us, and we can arrange then to release the will to them if for any reason they need it or want it.
Okay. Would you advise letting people know about where your will is, or what your will is, or is this a very kind of secret thing, or how does that work?
No, so I think historically it probably was, and people didn't like talking about it. But my view is that it's obviously, if you're appointing people to be executors, tell them, because they, you know, they need to know, and they will be involved at some point. And, you know, tell your family where the will is, or you usually, we will always provide a copy. We'll send an email with the electronic attachment, but we'll also send a photocopy for that to be stored at home. So, you know, tell people that I've got a copy. The original will is with my solicitors. There's a copy in the house if it's ever needed or when it's needed.
Would you say that applies as well for kind of guardianship, really including the people that you're wanting to give that responsibility to in that conversation?
Yes. I think it's important to make sure that the people that you're naming are willing to take on that role, because, as you know, being an executor, I've seen a question pop up, is quite a responsibility. And they do have obligations, and I think the question that I've seen mentions inheritance tax. And yes, if the estate doesn't pay inheritance tax within a certain time period, then actually the executor becomes personally liable, can become liable for it. So it's very important that executors know the role that they are taking on. And just to add to that, to answer that question, because I can see it there, inheritance tax does need to be paid within 6 months of someone's death, but it can be paid in instalments. So as long as a payment is made within 6 months, it doesn't have to be the whole amount.
Okay. There's another question as well about kind of that, you were saying very clearly that if someone's not legally married or civil partnership, then that's a tricky situation to be in terms of assuming where the money's going to go. If you make a will when you're partners and then you marry later, can you have written your will in a way that will protect for that, or will that just require that update that you were talking about?
That is such a good question, and I'll include that in the next one I do, because it's so important to say, and I didn't say it, and I don't know why, but marriage revokes a will. So if you have a will in place as partners and then you marry, the starting point is that marriage has revoked the will, so you're back to square one without a will in place. If you are doing it in anticipation of getting married, so if you came to me and said, oh, we're getting married next year, we don't want the will to be revoked from this marriage, then you can include in the will a line just to say, I am making this will and it's made in anticipation of my marriage that is happening next year on such and such date, and then that will make sure it's not revoked. But that has to be, you can't do that if you're kind of just, oh, we'll probably get married at some point. There has to be, you know, you are actually getting married in the future, and you're doing this will in anticipation of that marriage.
That's a great thing for people to include in their marriage prep, is like kind of book the photographer and write the will. There's been a couple of questions about donating your body to medical research. You mentioned it as well. I'll just take this opportunity that if people want to ask further questions about information on how to do that, donating it to Cardiff University, just get in touch with me. There's as well as writing in your will, it's a really good idea to let us know that you want that, and there's a form to fill out. What about if you've got assets abroad? How do you include them in your UK will, or do you need an abroad will, kind of depending on where that is? How does that work?
Again, it depends. It depends what you have abroad. So if you have a property, so that's a fixed asset, the easiest and the best thing to do is to make sure you have a will in that country to cover that property. So if you've got a villa in Spain, ideally you would have a Spanish will covering that property and how that passes, because there's obviously an interaction between different legal systems, and I have lots of clients with properties in France and Spain and Germany and everywhere, and they get dealt with differently. They don't have testamentary freedom in those countries. Luckily here we can choose where we leave our assets, and it can be to anyone or anything. Whereas in France, for example, and I think to an extent Spain, there is an enforced, is heirship. So you have to leave a certain amount of your estate to your children on first death. So it's very important, if you have a property in another country, to take advice there and make sure then, and communicate with your solicitor here as well, to make sure that the wills marry up with each other. There's always a risk of preparing a will here, and you can say that your UK will covers your worldwide assets, but it's how then the UK system, and especially if you've got trusts in the will, then interact with French and Spanish and other countries, their legal system that don't recognise trusts, and that can cause obviously quite a lot of confusion and unnecessary legal costs in trying to figure out a situation. Things more like bank accounts and money, if that's in a different country, that's classed as a movable asset, and it's a bit easier then for your UK will to cover those assets.
Okay, that's really useful. I think we are coming to the end of our time, but thank you so much, Laura, for your time, and for HCR Law for freeing you up for us as well. Thank you to everyone who's joined us today. Gifts in wills, like Laura was saying, about kind of philanthropic parts of wills, they accomplish extraordinary things here at Cardiff University, enabling students to take hold of the opportunities afforded to them here, and enabling transformative research to happen as well. And I'd love to talk to you more about that and what you can achieve through your will here at Cardiff University. Please do get in touch. My details will be in the email that you receive next week, along with a link to the recording and some other information too. So thank you again for taking the time to be with us today, and I hope you have a lovely afternoon. Diolch yn fawr iawn.
Thank you.